It's final. Only 50% reservation in India. The Supreme Court of India capped the percentage of reservation at 50%. A categorical verdict by the apex court held that under no circumstances the total reservation in education and employment should exceed 50%. The five-seater constitutional bench had scrapped the Maharashtra State Reservation for Socially and Educationally Backward Classes Act 2018. An amendment made in the Act in 2019 had enabled reservation to Maratha community in public education and employment. The apex court upheld an earlier order pronounced in the Indira Sahni case and the 102nd constitutional amendment. The Supreme Court asserted that exceeding the 50% limit laid down in the Indira Sahni case is violative of Article 14 and 15. Ashok Bhushan, L. Nageshwara Rao, S. Abdul Nazir, Hemant Gupta and S. Ravindra Bhatt were the five judges that constituted the constitutional bench which pronounced the landmark judgment. Though the bench were unanimous in their view but differed in the interpretation of Article 342A, which was inserted by 102nd constitutional amendment. 342A deals with the identification of communities in states as socially and educationally backward classes SEBC by the President in consultation with the Governor of the state. The five-member jury was divided in their opinion whether the state was deprived of their power to classify any community as SEBC. Justices Bhushan and Nazir viewed that the powers of the state were not deprived by Article 342A. But Justices Rao, Bhatt and Gupta held that only the President is empowered to identify and notify SEBC as per 342A. However, the three judges observed that the states can make suggestions for inclusions. But all the five judges upheld the sanctity of the 102nd Amendment. However, the interpretation of the majority three that only the President will have the powers to list out SEBC would stand. At the end of the day, the fact of the matter remains that only the President will be empowered in identifying the SEBCs and that the total reservation whatsoever be shall not exceed 50%. And now the bigger question and perspective of the verdict comes into the limelight. The scope of May 5 judgment from the 5-bench division bench of the apex court resonates far beyond Maharashtra and applies to all states and union territories. Moreover, the implication of the order puts an end to the power of the states to identify backward classes and provide reservation for them. Now, considering the Kerala perspective, the order has a very direct impact. In fact, the court was considering a bunch of similar litigations, including that of Kerala, which had recently enacted a 10% quota for economically backward among forward communities. Kerala has been promulgating implementation of 10% reservation for the economically backward section of the forward communities in the state. But now, it would be impossible to implement this without adjusting in other reservation percentages and limiting the total within the 50% quota as mandated by the apex court. No wonder Muslim fundamental organizations have come forth with their demand to scrap the reservation for the forward communities in Kerala. The Popular Front has urged the state government to scrap the newly added reservation for the economically weaker among forward communities. See how cleverly are the fundamentalist organizations operating? Now, it's up to the forward caste organizations to appeal to the President of India and get their genuine caste included. For this, a relook at the present reservation quota for the minorities and reducing their percentage in order to accommodate the economically backward from the forward caste is required. Let the 50% be reasonably divided among all eligible people and not stick to a good old scheme of things. The time is ripe to approach the constitutional head of the country and get things done logically, proportionally. The earlier, the better. Please subscribe the channel. Also, click the bell button to get the latest updates.